Okay, the last case is Del Monte versus R.J. Reynolds.
May it please the Court, Brian Stack and Robert Harris on behalf of the appellants, plaintiffs below. With the Court's permission, I would like to reserve 2 minutes for rebuttal. As the key case handed down by the Supreme Court following federal court precedent found, the doctrine of forum nonconvenience is predicated on the notion that a plaintiff may not elect to choose a deliberately inconvenient forum to vex, oppress, or harass a defendant. And this Court recently in the Telemundo case...
But that's not required.
Well...
It's not required that the plaintiff be properly motivated. The question is whether all the elements favor dismissal or not.
I agree that the issue is not motivation by the plaintiff, Your Honor, but the issue is, does the forum selection cause inconvenience or prejudice to the defendant? And that was the Court's holding in the Telemundo case.
No, I thought that the idea was that Florida should not be the courthouse for the world merely because Florida has the best lawyers.
It's not the courthouse for the world because...
Well, what is the contact with Florida? Why is this a Florida case? I understand why it could be a New York case or a Hawaiian case, but I can't understand why it's in Florida.
Well, the Court has subject matter jurisdiction, undeniably. The trial court does.
That is not the issue. Usually, and I think that especially in this case, these questions can be asked and can be answered unfavorably to the plaintiff usually, that by saying that this is a blank case which belongs there. This is a New York or Hawaii case which belongs in one of the 2 places. It is not a Florida case.
Well, it is a Florida case.
What happened in Florida that's relevant to this issue?
It's only a Florida case if we accept the misrepresentations in your brief. And I have to tell you, I'm very concerned about the writing of your brief. You start off on page 1 and claim that the facts are undisputed and say in inexplicable disregard for the undisputed facts, and then you go forward telling us what the undisputed facts are, which were not only disputed but clearly refuted.
Well, I believe so.
And then you go down that same path throughout your brief, and you claim that Del Monte Fresh's principal place of business and only office is located in Coral Gables. However, it is clear from the record that Del Monte Fresh Produce Hawaii Incorporated, the appellant, is not the same entity as Del Monte Fresh Produce Company. And
it isn't the same entity, Your Honor. You're correct in that regard.
Well, then how can you make such a statement and the way that you use the terminology in identifying the entity in such a confusing manner and then tell us this is not in dispute?
It is not disputed that Del Monte Fresh Produce Hawaii is based out of Coral Gables, Florida. The affidavit...
It doesn't do anything, does it?
I'm answering
I understand that, and I'm asking, this is my want, an improperly interrupting question.
It makes all the difference in the world, Your Honor, where the plaintiff is located. There is no dispute.
Was Del Monte Fresh Produce Hawaii ever a Florida entity? Yes,
no, it's a Delaware corporation. It's never been a Florida chartered company.
Has it ever operated any business in the state of Florida?
Yes. Currently, it operates out of Coral Gables.
What does it do?
Its primary business is...
Del Monte Fresh Produce Hawaii. You are saying, as an officer of this court, do you have any evidence to support that it operates out of Coral Gables? It doesn't even exist anymore. So,
it does exist. It is a validly chartered Delaware corporation.
Is it registered to do business in Florida?
It is not registered to do business in Florida. It is overseas.
Why isn't it? If it is,
I'm sorry?
If it is doing business, why isn't it registered to do so?
There is no requirement for it to be registered to do business.
That is not the question. you are invoking, this corporation as connected with Florida, and therefore and doing business in Florida, and therefore its choice of form is entitled to some respect.
That is correct. It's a business that is conducting.
If that is so, why is it not registered to do business?
I don't have an answer for that. I believe that's
Well,
an issue that's...
the obvious answer is that it's not doing business.
It is doing business. The business that it's primarily doing is remediating the Superfund site. I think where your confusion may be, Your Honor,
The Superfund site in Hawaii.
Admittedly, this is a complex case involving a Superfund site with the right of the plaintiffs to recover indemnity payments under the stock and asset purchase agreement. There's no doubt about that.
That agreement provides that it's governed by New York law, correct?
It does.
It was negotiated in New York.
No, it was not. There's no evidence.
Where was it negotiated?
There's no
Was it
evidence.
negotiated in Florida?
No, but one component of the stock and asset purchase agreement was a sale of a Florida entity, another affiliated company.
What does that have to do with anything?
I think where Your Honor's confusion may be is in Mr. Contreras' affidavit where he
I
said...
doubt that it's appropriate to refer to a judge's confusion.
I believe respectfully that Your Honor may be confused. Because the affidavit of Mr. Contreras, upon which we rely, which says Monte Fresh Produce Hawaii is doing business out of Dade County, is being assisted by its sole shareholder, another affiliated company. And I think that's where, or possibly could be the genesis of your question.
What evidence do you have that's in this record that Monte Fresh Produce Hawaii is operating, is doing business in the state of Florida?
Mr. Contreras' affidavit, where he says all of the oversight for the remediation occurs in Coral Gables, Florida. All of its officers, all of its directors, all of its banking, legal, and accounting, is conducted out of Miami-Dade County, Florida.
But what record evidence do you have that Monte Fresh Produce Hawaii is involved in that process?
It's in the affidavit of Mr. Contreras. It's in our sworn interrogatory
Does it have
answers.
a bank account?
Pardon me?
Does that corporation have a bank account?
It has banking accounts which I believe are administered by its sole shareholder.
Does it have a bank account in Florida?
I do not know if it has a bank account.
Well, isn't that sort of thing that is required if you are to overcome an abuse of discretion by the
No,
client?
because I don't believe that's what the focus of a forum nonconvenience analysis is, Your Honor. The two cases that I think most closely epitomize the situation are the Kinney-related cases that say if a company is operating, irrespective of where it's chartered or state of incorporation, if it's operating out of Miami-Dade County, that company is entitled to the highest presumption of deference allowed by law. This court
even if that is true, even if the plaintiff is entitled to deference and in the choice of its forum, that doesn't mean that forum nonconvenience cannot still be applied.
That's 100% correct. You're 100%
So
right.
that it does, in the circumstances of this case, you can give your client whose existence, let alone its presence in Florida, is entitled to some doubt, all the difference it wants.
That
doesn't make this a convenient forum to the exclusion of what is admitted to be a convenient forum in New York.
It's not admitted by anybody that it's convenient.
I thought you admitted that New York was an available forum.
For jurisdictional purposes, not because it's convenient, Judge. Nobody is based in New York. None of the defendants' officers, none of the defendants' employees.
But all of the witnesses, all of the people who negotiated the contract, or the vast majority of them are in New York.
That is not true.
And the contract is governed by New York law.
I've conceded that point. New York law is a de minimis point in this analysis because the law is the same.
But de minimis as opposed to the nothingness prevails.
It's practically nothing. But let's look at what is
I'm talking
convenient
about
about
your film.
Let me ask the court to consider what is convenient about New York. The defendants are not located there. They don't have an office there. They have no documents there. They have no employees there. They don't do business there, and neither do the plaintiffs. Yet
Where was the contract negotiated? Why does the contract...
It doesn't matter what the contract is negotiated.
Well,
What
It
matters
may
is
not,
where did
it
the
may
breach
not
occur?
matter, but can you answer the question?
Yes, sir. If I am.
Even if it's irrelevant, even if it doesn't matter what the answer is, or what the question states, please answer it.
The essence of the contract was the divestiture by a California company of its fresh food business. Whether it was negotiated in New York, California, Europe, is irrelevant. to the
Okay, it's
essence of this
irrelevant.
one.
Now, please tell me, where was it negotiated?
I don't have an answer for you. That is not in the record.
Okay.
And I submit it's
And
not
why-
in the record because
tell me-
it's not relevant
tell
to
me-
this analysis.
Tell me why it provides that it's governed by New York law.
Because the parties elected to have it governed by New York law. That's undeniable. I could not deny that. But what I can say is the defendants concede that New York law is the same as Florida law, and it's not unusual for a Florida court to apply New York law. That is a public interest factor. It's undeniable. But let's look at the private interest factors.
Did you concede at the hearing that after Del Monte Hawaii shut down in Hawaii, that the entire business operations in Hawaii shut down and there is no more ongoing operations for that subsidiary?
No, what I told the court was he wanted to know, because in the predecessor lawsuit in Hawaii, where Del Monte Fresh Hawaii was still in existence and still producing pineapples, why was there an allegation in that case in 1995? That's because that's where Hawaii was located. I said to the court.
Did you all, Del Monte Hawaii, make your principal place of business in South Florida? Answer, after Hawaii was shut down, the entire business operations in Hawaii shut down. There is no more ongoing operations for that subsidiary.
In Hawaii, he was asking about what was going on in Hawaii. Clearly, I would not have said that there are no more business operations when Mr. Contreras' affidavit, upon which we relied, said that all of the business was being operated out of Florida.
That's a total conclusion. What exactly did this Hawaii corporation do?
It's not a Hawaii corporation. It's a Delaware corporation with a principal place of business in Florida.
I'm referring to it as the Hawaii corporation, not an Hawaii corporation. The Hawaii, what exactly did officers, directors, or employees of the Hawaii corporation do in Florida?
It's business right now, and what it does is administer this EPA plan.
What did its employees do?
They
physically
process the claim. They are dealing with the EPA to this day.
Is there a piece of paper which is stamped Coral Gables, Florida, which is by
there are sworn interrogatory
operations of the Hawaii corporation?
Yes, there are sworn interrogatory answers signed under oath that this is what's going on out of Coral Gables.
But
That isn't what I mean. Is there evidence of the actual business? Is there a piece of paper, a receipt, a document, or anything?
That documentary evidence was not in the record.
Is there any such thing in the record?
No, there is not.
Thank you.
There is nothing in the record on that point, nor, I would submit, Your Honor, is it our burden as the non-movement to prove any of this. The burden of persuasion falls on each and every element on the defendants. And their contention at the hearing wasn't that Del Monte was not based out of Miami. What they said was, well, you know what, they're not entitled to any presumption. First of all, they misled the court on the law, and then said because of the other entity, any presumption that you might be thinking about giving them is defeated completely. And at that point, the trial court was set off on a path where it now was engaging in only a comparison of the number of witnesses in New York or in Florida. It completely
I
skewed.
thought there was a presumption of correctness on the part of the trial court.
Only if the trial court looks at the evidence and employs the evidence. But what the trial court did not do, Your Honor, is the trial court did not consider where is it really practically and least expensive to litigate this case. Do we uproot everything from Florida now? Let me remind the court that the defendant operates 2 blocks away from Del Monte in Dade County.
You refer to Del Monte, but Del Monte is separate. They're separate Del Monte
There
companies.
are. I should have said the Del Monte Fresh Produce Hawaii operates out of Dade County.
Isn't it Del Monte Fresh Produce Company that operates out of Coral Gables?
No, that's the shareholder for the entity that is here. Its shareholder as it has every right to do, conducts its business together with the officers and directors of Monte Fresh Produce Hawaii.
Let me ask you.
That's the way companies work, and that's the way multinational companies work when they're structured. If I could just make this one point, Judge?
No, counsel?
You're gonna have to listen to Judge Schwartz and then make your point.
I will.
He requires.
You don't have to.
But
You don't have to. But when a lawyer and a judge speak at the same time, usually the lawyer ceases speaking.
Yes, sir.
It doesn't matter who the lawyer is or who the judge is.
Yes, sir.
I'm going to ask you this question, which I think answers most form nonconvenience questions. Why do you think the other side does not want this case to be in Florida and wants it instead in New York?
Well, for the first reason I can think of is it delays everything yet again. What its other tactical reasons are?
For 15 years, how many years?
No, remember, the Hawaii Supreme Court...
Okay. That's the reason.
It's further kicking the can down the road.
You think that's the reason that...
Well, what reason would the defendant, who has no presence in New York, why would it want to go to New York?
I'm asking you, why do you think that?
Well, they claim, if I may, well, we have 3 witnesses who were involved in the drafting of the agreement.
I'm saying you think that is spurious.
It's completely spurious.
What do you think is the real reason that they want to go to New York and not in Florida?
Complete
I'll ask
delay.
the other side the same question about you.
Well, anticipating what they're going to say, because they've said it.
Why don't you just say what, in answer to the question that I asked you, why do you think they want to be in New York rather than in Florida?
What they have said to the trial judge?
No. What do you think is the real reason?
Delay. It's a delay play to push a case into New York, and whether New York accepts the case or not, it will further delay the proceedings even more. And justice delayed is justice denied from our perspective. But they will say, no, that's not our reason. We have 3 witnesses. And really, that is the spurious claim, because they don't say what those 3 witnesses are going to say. It's their burden to tell the trial court, these are the most important witnesses on the earth. And yet there's nothing in the record where those 3 witnesses are identified with specific knowledge.
What about your witnesses?
We have the plurality of the witnesses here in Miami.
And
5 of the lawyers that were involved either in and have knowledge of the stock and asset purchase agreement, section 4.4, which is the indemnity provision, or the 2001 confirmation agreement.
Were some of them children when these events occurred?
All of them were around during the execution of the confirmation agreement in 2001.
And does it say that the juror show what they would say and how that was relevant?
The interrogatory answer that we responded to was identify witnesses who may have information. We identified the topic area.
Why is it so difficult? You tell every witness, listen to the question and just answer the question. Then you may explain your answer. Why is it so difficult for you to do the same?
They were identified as knowledgeable about the indemnity provision.
Did it contain a statement which you say is necessary about what they would testify to and why that was important?
It did not contain a proffer of their testimony.
Thank you.
It contained a general summary of what they were going to testify about. And my point on that, Judge, is even in the order of dismissal, the trial judge identified and said Del Monte had 5 witnesses on the issue of the intention of the parties, which the defendant and the plaintiff agreed that the intention of the parties is irrelevant because it's clear and unambiguous, but in the event someone were to determine otherwise, Del Monte still had more witnesses in Florida on the subject of the intention of the parties.
Let me ask you this. Why did you choose Florida rather than Colorado?
We chose Florida as we had a right to do for 3 reasons. We're based here, we could get jurisdiction over the defendants here, and there was subject matter jurisdiction here, Judge. Subject matter jurisdiction on a claim arising out of where the defendants have a general...
Subject matter jurisdiction just refers to the existence of the jurisdiction of the court to consider the type of claim which is involved, which is a breach of contract.
That is correct, but that's not to say that New York or Colorado or Maryland or anybody else would have subject matter jurisdiction given these sets of parties. But it's not illogical for a corporation based in Dade County who, if we're right, is entitled to be paid in excess of $14 million in Miami-Dade County to sue in Miami-Dade County and say, pay us the money here. That's a logical thing to do. It is not logical for a defendant to say, you know what, we want to go to a state where nobody has set foot, except we have 3 lawyers from 20 years ago who might have something to say on this subject, but they don't tell the trial court. And the problem with what the defendant did, Your Honor, is we pointed out to the trial court the fact that Kraft contended that it had no connection to Dade County when we established the certificates of merger.
Kraft got to do it.
Because that is a logical reason to sue here. You ask, why did we sue here? We sued in the defendant's backyard. And that's both a private interest factor or a public interest factor, which this court in the Hilton case says is a legitimate reason and to which we are entitled the highest allowable deference when we elect to sue in a place that's convenient for us and not inconvenient for the defendants. So I respectfully suggest that we did not misstate any facts. The facts are those that are in sworn affidavits, and they haven't been disputed. To the extent that
Have not been disputed.
there is nothing in the record where they show that Monte Fresh Produce Hawaii is not in Miami-Dade County.
They dispute that Del Monte Fresh Hawaii was ever located in Miami and has ever done business in
No,
the
they
state
don't.
court.
What they say
They
now,
don't dispute that.
I don't believe that's anywhere in the record. I certainly could be wrong on that point. What they say is, you know what, you're really not doing business here because your shareholder is helping you. And
you're right.
because of that,
Your characterization of their argument is not exactly the characterization that they would make of their own argument.
well, I don't believe that they take the position that Miami-Dade County is a complete stranger or that the
Have you read-
plaintiff corporation.
I think that's exactly the position that they
Have you
take.
read the answer brief?
I have heard the answer.
You don't find their...
We've let you go way beyond because of the heavy questioning, but we'll still give you the time for rebuttal.
Thank you.
Good afternoon. May it please the court and counsel. I'm Suzanne LeBrit. It's my pleasure and privilege to represent Kraft Food Latin America Holdings. With me is Christina Alonso, who represents R.J. Reynolds.
Are you going to be taking up all the time?
No, Your Honor. I hope
Or
not.
then you
Now,
need
both
to-
of you are going to be taking on all the time that is allotted.
You have all the time that's allotted. We'll give you 15 minutes. So do you want me to alert you when you're at about 7.5 minutes?
We weren't planning to split the time.
Or you're going to take all the time for both? That was my
My
question.
colleague generously ceded
Okay.
the time.
You know it is not required that you use all the allotted
Well,
time.
perhaps you should in this case.
Or then again, perhaps you need not.
Well,
That's a question of judgment.
and I would like to use good judgment.
I guess my initial question is what deference was given to the plaintiff's choice of form? I understand we're on a standard review of abuse of discretion, which makes their position a lot more difficult. However, where was their choice of form given deference?
Well, I think that what the trial court's order reflects and how it went on at the hearing suggests is that the trial court looked at both of the plaintiffs, one being a Netherlands entity, which clearly is a foreign plaintiff and has zero.
The first 3 pages of the opinion are the court's analysis of what and to what extent the deference is due.
And I think the trial court cited the Irrigori case, which specifically refers to a sliding scale.
Well, let's not do the cases, because we know what the cases are and we know what the Kinney factors are. Let's go through what deference were they given. Is there any dispute that Del Monte Fresh Hawaii, this is the only place that they do business?
Oh, I think there's a big dispute about that.
Where else do they do business?
Well, if they do business at all, which from the...
Where else do they do business?
Hawaii. If they do business at all, they do business in Hawaii. And the business that they claim to do here, there is nothing, not one scintilla of evidence in this record that that business is done by Del Monte Hawaii. The evidence that's in this record shows that Del Monte Hawaii says that its business is done in Miami by Del Monte Fresh Produce. not by Del Monte, Hawaii. They are not registered to do business here. This is not where their registered agent is. Their own filings show that they are incorporated in Delaware. Their registered agent is in Hawaii. That is where they did their business. That is where they did their only business. And to the extent their business is being administered now, it is being administered in Miami by Del Monte Fresh Produce, not Hawaii.
Do they have an office in Coral Gables, Florida?
I don't know if they have an office in Coral Gables, Florida, or if they claim that their affiliate, Del Monte Fresh Produce, has an office in Hawaii.
Is there any evidence of a check written in Florida by the Hawaii Corporation?
None in this
Is there any evidence of any document or anything?
But what do you have to refute the fact they have an affidavit saying that Del Monte Fresh Hawaii does its business in Coral Gables, Florida, right?
Well, Your Honor, to be fair, what their affidavit says is that Del Monte Fresh Produce administers the business of Del Monte Hawaii. The affidavit does not say that Del Monte Hawaii made any indemnity payments in Miami or...
We're not going to indemnity payments. We're going to business. They're the plaintiff. We've got to look at the plaintiff corporation. The plaintiff corporation is Del Monte Fresh Produce Hawaii. It's the only one, right?
That's correct, Your Honor.
And they have an affidavit saying that that company does business in Florida.
Your Honor, not to be argumentative, and
it's a question.
Really
it's not...
request that the court look closely at paragraphs 3 and 4 of the Contreras affidavit, which is what we're talking about.
Correct.
And the words that are used there do not say that Del Monte Fresh Produce Hawaii is doing any of these things. Those words say that Del Monte Fresh Produce, not Hawaii, is doing the things that it's describing as being done for or on behalf of or somehow related to Hawaii. But not that Del Monte Hawaii is doing them. And I think that Judge Schwartz hit the nail right on the head when he said, if you are doing business in Florida, then why aren't you registered to business here? Why haven't you ever paid taxes here? Why haven't you generated any revenue here? There's sworn evidence.
Did I say all that?
I think Your Honor only says that why aren't you registered to do business here?
That's a nice way to ingratiate oneself to Judge Schwartz.
Not necessary.
But it's always appreciated.
If they were doing business here, then why don't they have the indicia of doing business?
They have an affidavit. The answer becomes, if they have an affidavit, what do you have?
They have a conclusory affidavit, and you, in order to counter that, in support of your contention that they don't do anything, it is difficult to show nothing by an affidavit.
It is a bit of a negative pregnant, I agree. What we have is the words that are in the affidavit, and those have been bantered about ad nauseum in the trial court and in the briefs and again here. But it is a short affidavit. It's mercifully short. And paragraphs 3 and 4, which I think on any kind of scrutiny will
Was discovery done on the jurisdictional aspects of this case? On the forum aspects of this case?
Yes, Your Honor. There are extensive discovery. A year's worth was done, and the record is filled with sworn discovery responses, which go to these issues and which ultimately never get to the answer that would give Del Monte Hawaii the predicate for a forum nonconvenience analysis that it needs, which is Del Monte Hawaii is not doing business in Florida and never has. And none of the things...
Even if it is, even if it were incorporated in Florida, even if it had its principal place of business in Florida,
those are the questions in Kinney.
The Kinney case was established to overrule the rule that mere fact precluded the application of a foreign non-convenience doctrine.
Well, the
questions in Kinney were
difference, the important aspect of that is if it was doing business in Florida, then it would be entitled to the deference that's required for a plaintiff who brings an action in their own forum. If they aren't an entity doing business and never have done business in the state of Florida, then they aren't They're not entitled to that deference at all.
Or they were entitled to a very minimal amount of deference, and I believe that's what the trial court gave. But even if the issue of the presumption that's afforded to the plaintiff, it informs the analysis of the private interest factors, which are where are the documents, where are the witnesses. And the answer here is there are no documents here except documents that we brought to produce for this litigation. And the witnesses are the witnesses that are in New York. The other witnesses, and this is really important to understand, to the extent this case goes for a determination of what this disputed indemnity provision means, it's either unambiguous and it's a determination of law, and what's going to come into play are the insurers, none of whom are anywhere near Florida. Most of them are in New York, California, Hawaii.
Who cares who the insurers are? It's the parties that count.
Oh, well, in terms of witnesses to the dispute at the time of trial, I think that we're obviously talking about from the private interest where the witnesses are located. But the other factors, assuming, even if Del Monte Hawaii was doing business in Florida, then we still have the ability to challenge for them, as we did. And assuming equipoise, which is at worst what was shown here, the public interest considerations do mandate the consideration of New York as an appropriate forum, and the trial court properly exercised its discretion.
How is New York any more appropriate than Miami-Dade County?
Because the witnesses are there.
There are witnesses here.
The only witnesses that are here that they've identified as relevant to this dispute are lawyers.
I can tell you only one thing, which is the same thing on the prior case. On a clean slate, I would have rendered a different decision, because I do believe that the plaintiffs are entitled to deference on their forum. The only problem here is we're on an abuse of discretion standard, and the trial court did presumably consider the Kinney factors.
And what I wanted to say, Your Honor,
and that's one vote.
That's one vote. The fact is, and this is undeniable, nothing...
I'm still hoping to persuade another judge, but I know how to...
Hope springs eternal.
Nothing...
That never is.
The Kinney factors... The Kinney factors...
Who was the judge here?
Judge William Thomas, Your Honor. The Kinney factors direct that the trial court consider, under the public interest factors, whether the resources of the state should be committed to a dispute that has nothing to do with it.
Why do you think they want to be in Florida rather than New York?
I think they have excellent lawyers here, Your Honor.
They have excellent lawyers in New York.
Well,
yes, but they have these lawyers.
They have these lawyers. You know, I don't know why they want to be in Florida.
I'm not asking you why these lawyers, these Florida lawyers, wanted to be in Florida. I'm asking you why the appellant wants it to be in Florida rather than New York.
At the risk of duplicating a frustrating answer, I don't know the answer to that, but I do know that the answer for Kraft...
Well, the real reason that many of these cases say, and I unfortunately have written a lot of them, saying that the mere fact that the people want to be in Florida because it's a good place to try a case, and the lawyers are very good on both sides, is not enough. The question is whether Florida should be burdened with a case which has no real connection with the state.
Your Honor, you couldn't have closed my argument better, and for those reasons, we respectfully submit.
And believe me, you have succeeded in ingratiating yourself.
Oh, and deeply humbling you, I'm sure.
For the reasons
and so you wish
I would like to respectfully request that this court affirm. Unless there are any further questions, I will sit down.
Thank you.
Thank you.
3 minutes.
Very briefly, even assuming the plaintiffs were entitled to no presumption at all, the court still the trial court neglected to consider 3 of the 4 private interest factors, and that has been determined to be, by itself, an abuse of discretion. What did the trial court not address? Access to written evidence. Counsel made an allusion to it, but all the written evidence emanates out of Florida or out of places in other states, nothing out of New York. All of the defendant's documents came from California. They don't have a shred of a document in New York. They only have those 3 lawyers that we don't know what they're going to say. The Contreras affidavit states that its business is operated through its officers, directors, and shareholders. Somehow that is made to be a deceptive way to do business, but that's the way corporations do their business.
Officers, directors, and shareholders of what corporation?
Of Monte Fresh Produce, Hawaii. And that is the way that company does business. Even if there is no presumption based upon the principal place of the plaintiffs, which I would suggest is appropriate here, this court in Hilton said the highest allowable deference also is to be afforded a plaintiff if they sue where it's convenient to them, and it's certainly convenient for us to sue here, and where we can get jurisdiction, personal jurisdiction of the defendants. Kraft is operating a block and a half away from Del Monte. Its principal business office is in Miami-Dade in Coral Gables, Florida. Its general counsel is there. Its director and officer is there. It's not illogical to say, let us devote the resources of a Florida court to a controversy where 3 of the 4 companies have some strong connection. And Judge, I understand that you have written possibly most of the forum non-convenience opinions. You will recall the Chiquita case, which came out right after Kinney. It involves my client, Del Monte. And what the court said in the Chiquita case is, we don't look at the formal headquarters of the litigant. What we look at is, where do they have a corporate presence? That's the linchpin of what Kinney says is important on a presumption. And it's undeniable, whether we are operating through our shareholder or through an officer or director, that these entities have a corporate presence in Miami, thus making our forum choice logical. Last point. Yes, when a trial judge weighs private interest factors after appropriately allocating a presumption on the forum choice, that is an abuse of discretion standard. But it is not an abuse of discretion standard when the judge at the outset...
Well, then what is the standard?
That's a legal determination. That's a legal error when a judge says, I am not going to give...
So if he does that, isn't the remedy to remand so that he can do that?
Well, what this court has said is
that
when the trial judge...
and we can do it ourselves.
That is correct. That's what this court has held, that when the trial court fails to employ the appropriate legal standards...
One of those Kawasaki cases or something.
I don't believe it's Kawasaki. It's cited in our brief.
If Judge Cortines, in this case, says that it's a Kawasaki case,
it is a Kawasaki. What I believe the Kawasaki case is the one that I believe Judge Sarando wrote a concurring opinion explaining how the standard of review is de novo in some cases where the trial court doesn't consider...
That is correct. There are those opinions. And my point here is, when you balance private interest factors against the weight of the presumption, I believe, and we respectfully suggest, the presumption is quite heavy here. And the judge boxed it out of the box. But even if you take away the presumption, look at the private interest factors that are in play in this case. Defendants don't even address 3 of them. They just say these witnesses, and we've countered that we have more witnesses here.
They're at the end of the argument, so we're going to have to bring it up.
I respectfully request the court to reverse the order of dismissal and to remand. And in the event the courts were inclined in any way to affirm, we have made the arguments on conditions of dismissal, which are, this court has, it's in our brief, at the last few pages of our initial brief. It's well established that there ought to be appropriate conditions of dismissal. Thank you.
Thank you both.